We live in a world where there are tripping hazards all over the place. The first thing I'll say is this, because I'm a firm believer that if you're going to bring your case to a jury, members of your community, the first thing they're going to say is, how come you didn't see it? What didn't you do? They will try to blame you. Now, my job as your attorney is to show that there is somebody responsible for causing this tripping hazard, and it was so unreasonable that they let that tripping hazard exist for an extended period of time in an area where they knew people were going to be walking and had the potential of falling. So a tripping hazard can be something as simple as a half-inch elevation or height elevation or difference in the concrete. Most municipalities have a statute that will define substantial defect as a half-inch or more in the height differential between two pieces of adjoining concrete. Tripping hazard could be something else. It could be a pothole. It could be tree roots on a sidewalk pushing up the concrete. It could be a slippery substance. Okay, there are any host of types of tripping hazards. The key question always is being able to describe with specificity what the hazard was, being able to document it early on in the process before it changes or gets repaired or disappears, and being able to establish that the property owner knew or should have known that that tripping hazard existed for such an unreasonable period of time that they should have fixed it and they left it out there, showing an absolute lack of care for people like you or me that are walking down a common sidewalk or across a parking lot. And unfortunately, you can sustain horrendous injuries because of that hazard. Bring all the information early to an attorney, let them do the investigation, and hopefully you'll be able to hold somebody responsible to compensate you for your injuries.